a court martial that had been already declared unconstitutional several times by the Constitutional Court. So we were taken to a court that was illegal in the knowledge of the state, that it was an illegal court. And the reason I give the background of the illegality that we have faced in the last about 1 year, that we seem to be in another wrong court.
omusumba ye n'asaba n'agamba bagawugule gagende ewakumuluma 13
naye gavumenti yakimukugamira ku mitwe
era mbyagalira ddala pulezidenti wange
betwasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka eza paka kulira
I saw the letter in the accused person, which he filed this month. This court had given the accused opportunity to put all his concerns in writing so that court is able to address them. Since he still wants to address court as per that letter, let him go ahead and address raising concerns.
That's obliged.
Lord, I hope you appreciate that. For example, if I want to communicate my anguish cannot be written, can only be seen on me. And so it's important that I speak and you capture how I look like. You can see what I feel. So, my Lord, on the first concern, by armed men who introduced themselves as Kenyan police, and we were instructed that we were under arrest. We were bundled from the meeting room into a vehicle. And apart from a short stop at a petrol station to fill their tank, the vehicle we were bundled in only stopped in Malaba, where after a short stop on the Uganda border, Uganda-Malaba police, where after a short while another vehicle came and we were put into it and driven straight to Makindye military barracks. So the first background to this is that we were really kidnapped and brought back to Uganda by force and detained in a military barracks. We are not soldiers. A court martial that had been already declared unconstitutional several times by the Constitutional Court. So we were taken to a court that was illegal in the knowledge of the state, that it was an illegal court. And it is that court that remanded us to Luzira prison where we still are. course, as everyone knows, the court was later on in January conclusively declared illegal and unconstitutional and scrapped. We remained in illegal custody after the court had declared, the court that remanded us as unconstitutional, because the remand warrant we were given, which took us to Rosera, expired. We had expected that following that judgment, if they still wanted to prosecute us, they would take us to a prison, to a police station, and a new process would begin. But we remained in illegal detention until we were charged in Nakawa in February this year. It is the Nakawa court that indicted us. Yeah, it is the Nakawa court that indicted us on the 29th of May of this year. And I have a copy of the indictment here. I don't know whether it is different from what you have, my lord, or what prosecution has or other people, because my indictment clearly states this is on the 29th of May, take notice that you will be tried, that is the three of us, A1, A2, A3. Take notice that you will be tried on the above indictment at the sessions of the International Crimes Division of the High Court, the Horden at so and so. So we were indicted to be tried at the International Crimes Division, which is a division of the High Court that is very different from this one by composition and by its processes, procedures. So, the reason I give the background of the illegality that we have faced in the last about 1 year, that we seem to be in another wrong court. And we don't know whether this is part of, again, a process that will just keep us delaying to have this matter disposed of. Second matter, my lord, is that before the summons for the warrant to bring us for beginning this trial, we had appeared before you in a matter of our application for mandatory bail. And arising out of the ruling that you made, which ruling seriously stunned us, because especially in your ruling, my lord, you indicated that the court was not aware of matters to do with our earlier charges in the court martial, in the general court martial. There was no record of a charge sheet and the case number. There was no record of the remand that we obtained on. All that was available to you was the case of Nakawa. That since the court can't be an investigator to find out what happened before, we made the conclusions that you did. This was very disturbing because not only were all the documents and details of the general court martial process filed together with our application, the very affidavit that we saw is myself, my colleague, friend here, Ajobeid Lutale. Both affidavits indicated how we had been arrested in Nairobi, how we were brought to Kampala, how we were charged in the court martial and remanded. Sections of the affidavit that I am referring to were concurred with, were accepted as truth by the prosecution. not contested. Of course, on top of that, our lawyers here in open court made extensive reference those very documents and to more than even what was filed. Those circumstances, you consider that it is still prudent that continue with the processes of establishing justice for us. That's all, my lord, that constitutes my and my. That's what constitutes the concerns to my colleague here, Haj Obeid, and myself wanted to present to you. As I have said, they are matters of very, very grave concern. We've been in jail for nearly a year now. We are not young people that can be adjustable. We have lost so much personal level that we would be doing. Yeah, so, my lord, I'm grateful that you have allowed us finally to present these concerns to you and to this court. In case the Judicial Service Commission has not extended our complaint to you, I have a copy here which we can gladly avail you, my lord. My colleague also has a concern here.
Thank you. Thank you so much, my lord. I would like to raise concern as pertain my presence before this honorable court. And my concern goes to the issues of identity. According to the amended charge sheet issued to us on 29th of May, identity. According to the amended charge sheet read to us on 29th of May 2025, it is stated that 29th May 2025, charge sheet, amended charge sheet.
Did we amend the indictment? We have never amended the indictment. Indictment, like amended text. Yeah, 29 was an indictment.
It is stated that the particulars of A3
That it is the indictment. indictment, not charge sheet.
29th May
There
2025.
was no amended charge sheet on 29. So charge number.
2025.
Charge
29th
sheet, indictment.
of May 2025. It shows that the particulars of A3 is RO 12 743 743 Captain Dennis Oola, male adult Ugandan, 48 years of age, and attached to UPDF Armored Brigade. UPDF Armored Brigade. Much as we seem to share the service number, which is RO 12743, and the same rank 12743, and the same rank of a captain, my names, H, and even the unit are totally different. For proper identification, I am RO 12743, Captain Denish. It is DENIS H. Oya, Oya, OYAA, Oola. And I am 43 years old of age.
My lord, the better pardon for a first name, just the first name. I didn't hear it well. His name.
Danish,
My lord, we want to respond when we know what he has spoken exactly. We want to know that his first name.
Danish, which is DENISH. Oya, Oola. I am 43 years of age, and I am attached to 5th Infantry Division of the UPDF. 5th Infantry Division of UPDF. My lord, I would like to seek the guidance of this court, whether this person is actually myself or I'm being kept on behalf of another person. That's all I have.
My land friend was extremely dishonest in that submission. Extremely dishonest. And I will substantiate. My lord, if you looked at the record, that statement is in a court order signed by the registrar of the court. Signed by the registrar. It's not up to him as a state attorney to begin impeaching an order of court as being defective. It's not up to him. I don't need to advise him that if indeed that was a typing error, there is a procedure for court to correct its own record. Under the sleep rule and all these other procedures. He knows. That has never happened, that this matter was ever brought to the attention of the lower court that handled the pre-trial process, where this record emanates from. Nowhere on record it's indicated that they ever moved the court to correct its record. Secondly, my lord, my reading of this, there is no typing error. The word, the phrase actually, that you will be tried on the above indictment at the sessions of the International Crimes Division of the High Court. Well structured in perfect English. International Crimes Division of the High Court, boldly stated, with no typing error at all. So it is disingenuous on his part to begin purporting at this stage that there is a typing error on record. Related to that, my lord, again, the submission he made, that he finds no issues with this honorable court proceeding with the matter which was supposed to be transmitted to the ICD, which was committed to the ICD, because these are committal orders. The committal order is that ICD, that he finds no issue with the file being diverted to the Rongo division. I want to substantiate the submission made by Senior Counsel Martha Karua, the lingering question how the file found its way here. I'm trying to figure out, my lord, the clerk who got the file from Nakawa Court with the orders, take this to ICD. How did this clerk end up here? How? You are armed with a file from the lower court, the magistrate court, deliver at the registry of ICD. He or she decides to divert the file and bring it here. That speaks volumes about the propriety of the whole process we are trying to interrogate now. Then the last issue, my lord, that particular matter, Mr. Biruvumbuka submitted that these are all the same court. I mean, it's all the same. ICD and these criminal divisions, they are all the same. High court with unlimited jurisdiction. I wouldn't expect that from him again. I wouldn't. That submission, my lord, is neither here nor there. In other words, he's suggesting that actually the land matter can find its way here for a family cause. There is a family division. There is a land division. My lord, can you handle land matter simply because it's high court or commercial transaction? So the instruments establishing these divisions of the High Court are redundant. They are made in vain, superfluous. For the record, my lord, ICD is a creation of the law. It is the Constitution, the High Court, in bracket, International Crimes Division Practice Direction, 2011, and in the recital there, my lord, you will see, made under Article 133, Clause 1A and B of the Constitution of the Republic of Uganda. The High Court, International Crimes Division Practice Direction 2011, made under Article 133, Clause 1AB of the Constitution of the Republic of Uganda. And in Clause 3, Paragraph 3 of that practice direction, establishment of the division. The division established in 2008 under the War Crimes Act, no, under the International Criminal Act, International Crimes Act rather, as the War Crimes Division is hereby designated as the International Crimes Division. And my lord, there are rules, specific rules regulating the processes or the procedures before that court, which are totally different from the rules governing this court. And that is the Judicature, in bracket, High Court International Crimes Division Rules of 2016. They are quite elaborate and detailed rules. I don't want to labor you, to waste your time, my lord. And my lord, the peculiarity of this court, the uniqueness of this court is not only seen in the processes and procedures provided for under the rules, but even the composition of the court. My lord, the practice direction which I have just cited clearly indicates that there are situations where the court can sit as a panel of 3 justices of the judges of the High Court, which is not the case in the High Court Division here, the High Court Criminal Division. It's not the case. Here it is constant, one judge in all these cases. But International Crimes Division, there are cases where, or rather, there are cases that it may require a panel of 3 judges. Who knows that? Maybe this could be one of them. He indicated that Mr. Baguma submitted that the jurisdiction of the other court is limited to war crimes, genocides, crimes against humanity, and terrorism, and so on and so forth. But I would like to draw your attention to paragraph 6 of that particular direction, practice direction. Without prejudice to Article 139 of the Constitution, without prejudice. So this particular instrument is predicated on the provisions of Article 139, which talk about the jurisdiction of this court. That the division shall try any offense relating to genocide, crimes against humanity, war crimes, terrorism, human trafficking, piracy, and any other international crime as may be provided for under the Penal Code Act Cap 110 or Geneva Convention. Any international crime. When you look at this instrument, the particulars, they are indicating this is a cross-border crime. Kenya, Geneva, Switzerland, wherever. That could have been the reason why the lower court deemed it necessary to refer this matter or to commit it to the ICP, which is well suited to handle those matters, my lord. For your case, my lord, your jurisdiction is restricted here. You can't handle international crimes. Cannot. But for the ICP, they have that mandate to handle international. For the record, by the way, it was established for that particular purpose, cross-border crimes. So I want to conclude, my lord, to wind up my submission on the issue he raised that they intend to apply for an amendment. That is not a matter to be raised here. No. Surely, my lord, that should even be considered at all. Their intention, they are giving you a notice that they intended to amend. Then, if they wished to do so, they know what to do. So must this court proceed with an illegality as they wait for the state to effectuate their intention? And even if it was a typo error, a typographical error, if they want to suggest that actually the whole directorate of DPP is that incompetent not to detect that mistake up to this particular moment, that they could not correct it at a lower court, and they want to smuggle in an application here where you do not even have, this court is not clothed with jurisdiction to entertain such matters. Those are matters to be handled at a pre-trial level before the Chief Magistrate Court, if they so wished. So there is no need of citing Section 51 of the TIA here. No need. It's not this court which prepared this indictment. The lower court. So we reiterate the prayer, my Lord, that you be pleased to allow this file to find its appropriate destination where it was supposed to be dispatched. Maybe this was a stopover on its way to ICD. Its itinerary is very clear from Nakawa, maybe pass here briefly to CID. Let the journey continue up to its final destination. We do so, pray, my Lord.
So 30 years ago today, exactly today, and has maintained the right to a fair trial in a language that is so clear both in its purpose and in its effect. My Lord, the specific article is 28. It speaks about an impartial tribunal. Independent and impartial. My Lord, the Constitution did not just stop there, because
In Article 44C, it also provides that the right to a fair hearing cannot be derogated from. There are no circumstances at all of any nature in the law, in practice, wherein that right can be derogated from. My Lord, what I hear the accused raising which is consistent with their duties as citizens, to safeguard the rule of law, is that they apprehend that this right which is enjoyed by them, not by the court, by them, is in the kind of danger that Article 44C sought to ensure does not manifest at all. My Lord, their duties are in the national objectives and directive principles of state policy. I think it is 29 that deals with the duties of the citizen. My Lord, my learned friend for the state may not have fully appreciated what is at stake here. It is not a light moment. It is not just an opportunity for the accused to speak to the court. But it is the accused putting on record their real and palpable fear that they will not get justice if the court, as constituted, continues to deal with this matter. My Lord, this court derives its power from the people of Uganda. And it is enjoined to exercise that power in accordance with the values and the norms and the aspirations of the people of Uganda. Lord, the accused are part of the people of Uganda. And it cannot be one of the norms or among the values or aspirations of the people that where there is a pending complaint of the nature described by A1, that this court could still be seen to be independent and impartial. Lord, when I look at this audience in the court, I see one individual who, this is from my memory, who is in this court who participated in making this constitution. And his signature is on it. If we were to find the original version, we would find his signature. He is A1. So he raises issues that are pertinent to him, both from a historical perspective and from an aspirational perspective. And from his experience over the last 1 year. My Lord, I rest.
My brother, so there was no application to have you removed from your position as a judge. They simply said they filed a complaint at the Judicial Service Commission, which among others seeks to. So we cannot be hard to say that the accused persons want you out of your office. So ordinarily shouldn't be something that my brother should be responding to. Just a minute. I've just been patient. And my Lord, I pray that even if I seek him to respond to the rest, that should be expunged from the record. Because it shouldn't have even come up at any point. Because as a prosecution, we never responded. We never said anything about that. And the rules of procedure are very clear. That you can only make a rejoinder on what was said in response. Did we mention anything to do with the victim's application? Did we mention anything to do with an application to have you removed from office here before court? Did we say anything about perennial? So I think as it proceeds, they should stick to what we said in our response. Thank you. Just two issues, my Lord. They talked about a court order from Nakawa. Yes, my Lord. Yeah, one court order. The court order from Nakawa. Two, that the committal to the ICD. And I will limit myself to those ones. And court will be able to appreciate as to whether there were new matters or not. Because we wouldn't want court to be misled. Okay, let me see it.
He chose to gloss over the thing. It's not our problem. These are not issues. Then the prosecution will respond, the court will determine whether there are new issues or not.
Most obliged, my Lord.
If it's granted.
Most obliged, my
The court
Lord.
will tell whether there are new issues.
Most obliged, my Lord. My Lord, my senior colleagues were alluding fact that there was a court order from Nakawa directing that the accused persons be tried at the international so that it was a court order directing that the accused persons be tried at the International Crimes Division of the High Court. Which is wrong. There is just a notice. There is a notice which is attached to the indictment. That is not an order. And that's why I am of the view that that was a new matter that we needed to respond to. It is a submission that what they are calling an order is just notice. A notice which the deputy registrar can change any time. It cannot be an order. There's nothing that I order. We pray that court disregards that. Then, my Lord, they also brought a new fact that the accused persons were committed to International Crimes Department. I refer to the first page of the indictment, whether it has International Crimes Department, Division of the High Court. And this is why we were submitting that this was a typo error, because it has Nakawa. It does not have International Crimes Division of the High Court. They also brought a new matter in that same thing, my Lord, that the International Crimes Department, Division of the High Court, has jurisdiction over the charges that the applicant, the accused persons are facing. My senior colleague, Lukwago, cited Rule 6. My senior colleague, Elias Lukwago, cited Rule 6. And I think his interpretation is way far from what the rule provides. My Lord, I just want to read this verbatim. That the division shall try any offense relating to genocide, crimes against humanity, war crimes, terrorism, human trafficking, piracy, and any other international crime. My Lord, my senior colleague brought a new issue where he submitted that treason is actually an international crime, and that it should be tried by the International Crimes Department. Yes. We invite court, my lord, to disregard that. We so pray.
That the order of committal, the act of committing actually results in an order of committal, not a suggestion. Once committed, the file has to be transmitted to the High Court. And there are instances where the committing court finds no offense and discharges an accused person. So the whole process must result in an order, either of committal or discharge. You, my learned colleague here, cannot resist the fact that what we are having is a committal order directing committal to the International Crimes Division. And he is the one who had referred to the matter in his submissions, and at that time happily suggested amendment. So, like my learned friend Panga, I would urge the court not to be misled, to agree with Birigumbuka that committal proceedings result in anything else but an order. It is not a suggestion. It is an order of either committal or discharge. And we are dealing here with an order of committal which cannot be amended, not by the prosecution. Wednesday, is that day okay? To raise his complaints orally in open court. He has raised them very well. I do not wish to summarize because I'll be diluting. You have the clips. Let the people of Uganda know what the issues he and his colleague Lutale and even Captain Ola have raised today. The case has been adjourned to the 15th of October, when the court will make its ruling. But one of the issues I can say was his recusal. Yeah.
Dr. Besigye raisinze ensonga 3 ne Ola naye n'araisinga ensonga y'emu, ensonga 4 nga za muzinzi era nga ziraga nti wano bino bye balimu bya kimenya amateeka, bali mu kumenya amateeka ebigenda mu maaso. Ensonga 3 eza Dr. Besigye zaleese, esooka kwe kulaga nti bamujja e Nairobi ne bamuyisa ku boda ne bamukomyawo mu bumenyi bw'amateeka. Amateeka gaffe gakirambika bulungi nti omuntu gwe bakidnappings oba gw'obawambye okuva mu ggwanga eddala n'omukomyawo wano tosobola muteeka mu mbuga z'amateeka n'omuvunaana. Era eyo ensonga nkulu nnyo Dr. Besigye agiggyeeyo. Eyookubiri, Magistrate Court e Nakawa yagamba nti Dr. Besigye atwalibwe mu ICD, International Crimes Division, eyeteekebwawo etteeka ddamba erina n'agikulira n'abalamuzi. Era waliwo wekyetaagisiriza ng'erina kutuuza pano y'abalamuzi 3 ng'omusango munene oba guyimu ensonga nnyingi ne baga nti omuntu ajja gisobola oba fayiro tajja gisobola keesi eyo bateekewo abalamuzi 3. So ICD, International Crimes Division, fayiro gyeri. Kati ensonga eri eyeebuuzibwa nti fayiro gye baaweereza mu ICD ejja etya wano? Baguma yagifuna atya? Bagitikka bakiraaka bagitwale mu ICD, ani yaginterceptinga mu kuba awo n'agiyimiriza n'agidivertinga n'agireeta mu kooti wano. Ensonga ey'okusatu no mbufunze ng'alaga nti wano ali mu kooti nkyamu. Dr. Besigye ne Obedi ne Ola bali mu kooti nkyamu. Omusango guno gulina kubeera mu ICD so si wano. Ensonga ey'okusatu y'ey'okugamba Baguma nti ali incompetent, nti tasobola wamunguuba mu ntegeera y'amateeka tagategeera bulungi era tajja kusobola kuwa bwenkanya olw'ensonga nti engeri gy'azaakwatamu ensonga zino ziragira ddala nti abulamu nnyo omutindo ogwetaagisa omulamuzi ate nga ssemateeka alaga mu Article 144 nti omulamuzi bw'obanga totuukiridde mutindo ogw'okuteekateeka n'okulamula obulungi osobola okuggibwa ku bulamuzi. So Dr. Besigye yateekayo musango gwe mu Judicial Service Commission ng'agamba ekitongole ekyo kuba kyekikangavvula abalamuzi nti ono mukulu Baguma gwe muweereza n'okulamula abantu omulimu tagusobola, amateeka tagategeera bulungi. N'olw'ensonga eyo Dr. Besigye ng'agamba tasobola kugenda mu maaso Baguma ng'awuliriza omusango ng'ate ne Dr. Besigye amuvunaana mu Judicial Service Commission oba akakiiko akakangavvula abalamuzi. N'olw'ensonga eyo ng'agamba Baguma omusango aguveemu kubanga naye yennyini amuyina Dr. Besigye amuwabira omusango obadde ebbali. So ezo nsonga ssatu. Mukulu Ola n'aba nga ye ensonga ye gy'aleese yakugamba nti wano baleeta muntu mukyamu mu charge sheet. Gwe boogerako ye Dennis Ola yali mu charge sheet. Naye ye nga yagamba ye Dennis Ola. Era gwe boogerako mu indictment oba mu mpaabi nga wa myaka 48 mu kiwandiiko kya state ye ng'agamba ye wa myaka 43. N'olw'ensonga eyo gagamba oli gwe boogerako Ola Dennis mulala era nga ye yennyamira nti agamba amaze ebbanga ligenda kulala emwaka mulamba ng'ali mu kkomera yeebaseeyo ku lw'omuntu omulala gwe bataakwata era gwe bataaleeta kati ng'alaga nti waliwo obutali bwenkanya gy'ali. Kati ensonga ezo state weezizzeemu mu ngeri gyezizzeemu mukulu Birivumbuka omulamuzi kwe kugaa nti ajja kuwa ensala ye ng'ennaku z'omwezi 15. Waliwo bail application era tumulaze nti yagaana mandatory bail n'alemesa Dr. Besigye okuteebwa n'agamba nti ye bya General Court Martial yali tabimanyi by'okumusiba nti yafuna ennaku 18 zaali tezinnawera bamukomitingira nga 29 Ogwokutaano n'amumma bail. Mugamba nti kakati era mu ruling eyo mukulu Baguma yennyini n'agamba nti ye kyalaba Dr. Besigye ne banne baalivudde mu kubonaabona n'okwetaliira kooti nti basaba bail batunulire kimukuliriza main case. N'abanga bail alinga yagisala edda obanga abalaga nti ne munaamala ebiseera nga musaba bail mumala byambulago tebagenda kubawa bail. So nga tumuga tasobola kugenda mu maaso nakulira application eyo. State ye badde eremerako ntugende mu maaso naye asazeewo nti ejja kujja 15 ku mention si kuwulirwa 15 guno naye mention ogyogerako bwogezi tulabe ekinaaba kizeeko. So katulinde ku olwo ensalawo bwe naabeera.